This 14 minutes module is relevant to final exam students of Chartered Accountant course. Paced-Set-A Module1, Appointment of Director under Companies Act 2013. This module explains and covers these topics: Appointment of Directors Section 152, First Director, Appointment of Subsequent Directors, Other Requirements of Appointment, Retirement of Directors by Rotation Section 152, 6, Examples of Retirement of Directors by Rotation, Filling Vacancy of Rotational Directors, Deemed Reappointment of Retiring Directors, Section 152, 7, and Exemptions. By viewing this module periodically or frequently, the topic's understanding can be grasped easily. Please give it a try. If you like this module, please give your thumbs up and like. This will give me motivation to make more such modules.
Let us study about appointment of directors under Section 152. The appointment of directors in a company is governed by Section 152 of the Companies Act 2013. The directors are generally appointed by shareholders in general meeting. Some directors may also be appointed as per company's rules, that is, as per Article of Association. Every company should have directors. Then question may arise: what is first director? If a company's articles do not specify the first directors, the individuals who signed the memorandum become the first directors until official appointments are made, as per Section 152, 1. For a one-person company, the sole member automatically becomes the first director until they appoint someone else. Normally, the articles of company mention the first directors. If not, the subscribers, individuals, to the memorandum take that role. Please note that companies or corporate bodies cannot be directors. The first directors serve until proper appointments are made, usually by the first annual general meeting. In a one-person company, the single member is the first director but can later appoint others. Appointment of subsequent directors. By default, every directors are appointed at a general meeting of the company, where shareholders make decisions, as mentioned in Section 152, 2, of the Companies Act 2013. However, there are exceptions where the Companies Act allows a different procedure. For example, the Board of Directors can appoint additional or alternate directors if the company's articles allow it. Other requirements of appointment. Director Identification Number. A person can only be appointed as a director if he has a DIN, issued under Section 154, or any other prescribed number, as per Section 153. Providing DIN and declaration. Before appointment, the proposed directors must provide their DIN. Declare that they are not disqualified from being a director, as per Section 152, 4. Written consent to act as director. A person cannot act as a director unless they give written consent in Form DIR-2 before appointment. The company must submit this consent to the registrar within 30 days by Form DIR-12 along with prescribed fees, as mentioned in Section 152, 5, and Rule 8 of the Company's Rules 2014. If the person is from a country sharing a land border with India, security clearance from the Ministry of Home Affairs is required. Let us take an example. Mr. Naresh wants to become a director in Global Services Private Limited. He must first apply for a DIN, if he doesn't have one. Then, he must give written consent, Form DIR-2, to the company. The company must file this consent with the registrar, Form DIR-12, within 30 days. Appointment of an independent director. When appointing an independent director at a general meeting, the notice for the meeting must include an explanatory statement. This statement should confirm that, in the board's opinion, the person meets all legal requirements for the role as per Section 152, 5. Exemptions from Section 152, 5. Government companies, directors appointed by the central or state government do not need to furnish written consent. Section 8 companies, non-profit companies also exempt from this requirement. Note, these exemptions apply only if the company has no pending financial statement, as per Section 137, or annual return filings with the registrar, as per Section 92. Retirement of directors by rotation as per Section 152, 6. This rule ensures that company management does not become self-perpetuating, meaning the same directors cannot control the company indefinitely. Why is this important? If directors could re-elect themselves without shareholder approval, it could limit company growth and reduce accountability. Shareholders, as company owners, cannot interfere in daily management but can choose not to re-elect directors they disapprove of. Key provisions of Section 152, 6. Rotational directors and retirement process. At least 2/3 of the company's directors must retire by rotation and be appointed by shareholders in a general meeting. If the company's rules, articles, do not specify a different system, these directors must retire at regular intervals. Non-rotational directors. The remaining directors, less than 1/3, are not subject to rotation. They are also appointed by shareholders in a general meeting, based on company rules. This system helps maintain fresh leadership while keeping shareholders involved in key decisions. Retirement of rotational directors. Who retires and when? At the first AGM after appointing directors, and at every AGM after that, 1/3 of rotational directors must retire. If the total number of directors is not exactly 3 or a multiple of 3, the number closest to 1/3 will retire. Who must follow this rule? This rule applies to public companies, private companies that are subsidiaries of public companies. It does not apply to private companies that are not subsidiaries of public companies. These companies can choose to have only permanent directors if their company rules allow it. Who is considered a rotational director? At least 2/3 of a public company's directors must be rotational directors. Independent directors are not included in the total number of directors and do not retire by rotation. What about nominee directors? Directors appointed by financial institutions, the central government, or the state government, due to shareholding or agreements, are not considered rotational directors. This system ensures regular changes in management while maintaining stability. Let us understand this concept by examples. Calacata Limited has 12 directors, including 2 independent directors, who are not counted for rotation. 1 nominee director, also not counted for rotation. As per the provision of Section 152 of the Companies Act 2013, the concept of retirement by rotation of rotational directors shall be applicable to public company. Let us see step-by-step calculation. Total directors equals 12. Exclude independent and nominee directors, that is 12 minus 3 equals 9 directors. At least 2/3 of these must be rotational directors. So 9 into 2/3 equals 6 directors, who are liable for rotation. At every AGM, 1/3 of rotational directors must retire. So 6 into 1/3 equals 2 directors will retire at the AGM. This ensures board changes while maintaining stability in the company. Let us understand by some other examples. Example B, company with 6 directors. Rotational directors equals 6 into 2/3 equals 4. So directors to retire at AGM equals 4 into 1/3 equals 1.33, which is rounded to 1 director. Example C, company with 7 directors. Rotational directors equals 7 into 2/3 equals 4.7, which will be rounded to 5. Please note that this cannot be less than 2/3. Now directors to retire at AGM equals 5 into 1/3 equals 1.67, which will be rounded to 2 directors. Example D, company with 9 directors, including 3 independent directors. Independent directors are excluded. So total counted directors equals 9 minus 3 equals 6. Now apply the same rotational retirement rule as shown above. This system ensures gradual board rotation while maintaining leadership stability. We have seen how many directors will retire till now. Now let us see who actually retires at the AGM. Longest serving directors retire first. Those who have been in office the longest since their last appointment must retire. If multiple directors were appointed on the same day, they decide among themselves who will retire, by mutual agreement or by drawing lots, random selection. This ensures fair rotation of directors while maintaining stability in the company. Filling vacancy of rotational directors. Replacing a retiring director. At the AGM, the company can either reappoint the retiring director or appoint a new person, following Section 160 rules. Important rules. The number of directors must not go below the legal minimum. If the company still meets the minimum requirement, it can choose not to appoint anyone in place of the retiring director. What if the AGM is delayed? Rotational directors must vacate their position on the due date of the AGM, even if the meeting is postponed. Non-rotational directors. 1/3 or fewer of the total directors do not retire by rotation. They are appointed either at a general meeting or as per company rules. This process ensures smooth board transitions while keeping company governance stable. Deemed reappointment of retiring directors, Section 152, 7. If the vacancy is not filled at the AGM. If the retiring director's position is not filled and the meeting does not resolve to leave it vacant, the meeting is adjourned. The adjourned meeting will take place on the same day next week, at the same time and place. If that day is a national holiday, the meeting will be held on the next working day. Automatic, deemed, reappointment. If the vacancy is still not filled at the adjourned meeting and no resolution is passed to leave it vacant, the retiring director is automatically reappointed. When reappointment does not happen, a retiring director will not be reappointed if a resolution to reappoint him was voted on and rejected. The director declined reappointment in writing. He is disqualified under the Companies Act. A special or ordinary resolution is needed for his appointment. Section 162 applies, which prevents multiple directors from being appointed through a single resolution. This ensures fair and structured board management while preventing indefinite tenure of directors. Exemption. Exemptions from retirement and reappointment rules, Sections 152, 6, and 152, 7. The rules for retirement of directors by rotation and automatic reappointment do not apply to government companies, which is unlisted. If 51% or more of the company's paid-up share capital is held by the central government, or any state government, or both central and state governments together. It is also not apply to subsidiaries of such government companies. However, there is following condition for exemption. The company must not have defaulted in filing financial statements, as per Section 137. An annual return, as per Section 92. Legal reference for this is Notification Number GSR 463, E, 2015, amended by GSR 582, E, 2017.